For today's case, we cover a situation in which a prisoner claims that a correctional officer got other correctional officers to beat him up while he was in custody, and he claims, therefore, excessive use of force in violation of law. This turns on an administrative issue to determine whether or not the prisoner properly preserved his rights to bring the issue, and what administrative remedies he had to seek and how to go about seeking them before he could go to court. So let's learn a little bit more about the issue, how the prisoner brought the litigation, and whether the prisoner forfeited his rights by improperly bringing the litigation or making a mistake along the way. Let's get started with this. The respondent claims that during a pre-trial detention period, while he was in Maryland State Prison, the petitioner, who was a correctional officer lieutenant, ordered 3 other guards to attack him, and therefore sues for damages under 1983 to alleging excess force. So it's not because he was misbehaving, it's not because we need to gain control of him. We're basically doing it for some sort of form of revenge, which, not so much. You can't do that. You do have an affirmative duty in this situation, by the way, as a police officer or a correctional guard, because he's in custody. So first of all, you couldn't do it in any event. Second of all, you do actually have an affirmative duty in the situation because he's in state custody. And so, that violates that as well. Prior to trial, the relevant guy, the petitioner, the correctional officer, moved for summary judgment under a relevant federal rule, arguing the prisoner had failed to exhaust administrative remedies. So we think that, you might have a claim, but you didn't do exhaustive administrative remedies. Now, incidentally, this is in state level law, which doesn't necessarily, as a matter of state law, require exhaustion of remedies. If this were federal, then yes, we have to exhaust remedies first. But state law, it depends on how the state law is written. So they're saying you didn't exhaust administrative remedies and our state requires you to. Okay. The relevant rule requires the district court to enter a judgment on a claim if there's no genuine issue of fact and they're entitled to judgment as a matter of law. So if it's true that you had to exhaust administrative remedies first, and if it's true that you didn't do that, then yes, judgment as a matter of law, right? There's not an issue of fact. It's an issue of law. You just didn't go about it right. Go talk to the administrative agency first, then maybe talk to me. You missed a step along the way. The district court denied the motion, finding no dispute that Maryland's prison system had internally investigated the assault and concluding this inquiry satisfied the obligation. So the district court says, well, if he does have an obligation to exhaust administrative remedies, he has done that. He's already done that, and now he's here. So I don't even know what you're complaining about. He's already done the administrative thing, so he's in the right place, assuming he had the obligation in the first place. Great. At trial, the individual did not present evidence relating to the exhaustion defense. So he had said, I can't be brought here because you didn't exhaust administrative remedies. He brought that as a matter of law. The district court ruled against him. At trial, he didn't offer any evidence about that. So he didn't say, well, here's evidence about that. He didn't offer any evidence along those lines to say, the administrative remedies that did or did not take place. The jury found the defendants liable for $700,000 in damages. So pretty bad beating, I guess, of a prisoner. So yeah, these 4 guys conspired against him to beat him up. They did beat him up. $700,000 in damages. The individual, the lieutenant who had ordered this, did not file a post-trial motion, which would have allowed a disappointed party to file a renewed judgment for judgment as a matter of law. So you can also, of course, ask for a judgment as a matter of law at the end of a case. You ask for it in summary judgment, and you can also ask for it at the end of the case as well. A judgment notwithstanding the verdict, right? So the verdict is, how about guilty or how about liable? So technically speaking, there is a slight difference between a judgment notwithstanding the verdict and a judgment as a matter of law, right? So a judgment notwithstanding the verdict would be the court saying, okay, I think based on the evidence, not guilty or not liable. I disagree with the jury. That's a judgment notwithstanding the verdict, right? The jury returns a verdict, but only the court enters judgment. There is a legal distinction between a verdict and a judgment. Juries do verdicts. Courts do judgment. So a judgment consistent with the verdict would be guilty or liable. How about guilty or liable, as the case would be? That would be consistent. But a judgment notwithstanding the verdict is guilty or liable. How about not guilty or not liable? I don't know what evidence you were looking at, jury. I don't know what evidence you were looking at, but this is clearly not guilty. I don't know what you're doing. All right, a judgment as a matter of law is technically different because it's like, upon further consideration, upon renewed consideration, it was legally impossible. It's not that the jury made a mistake. It was legally impossible for them to do this. I should have filed that. I should have given that summary judgment. I don't know what I was thinking of, and I should have really done that in the first instance. I'm so sorry. My bad, but I can fix it now by giving a judgment as a matter of law. So, but he didn't ask for that. He didn't ask for his renewed judgment in law. He didn't ask the district court to, have you reconsidered that whole thing from the first start, that you should have granted that motion of summary judgment long, long ago? Have you reconsidered maybe doing that now? Didn't ask. So he appeals to the Fourth Circuit on the rejection of exhaustion defense. Uh-oh. Did he preserve his issue? Did he preserve it? Well, he asked for a motion for summary judgment, but he didn't bring any evidence at trial, and he didn't ask for a renewed motion at the end. So did he preserve his issue? Can he do that? The Fourth Circuit, bound by precedent which holds that any claim or defense rejected at summary judgment is not preserved for appellate review unless it's renewed, dismisses. So do you have to renew it or not? The Fourth Circuit says you do have to renew it in order to preserve it. So do you have to renew that objection? Do you have to renew that motion? This is incidentally one of the reasons that lawyers do all these renewals and keep asking and keep re-asking, because they want to make absolutely sure they preserve the issue. This guy, for whatever reason, didn't do that. So is his failure to do that a problem? Do you have to file the motion in order to preserve the issue? The Supreme Court says the post-trial motion under Rule 50 is not required to preserve review on a pure legal issue that's resolved at summary judgment. So no, you didn't have to bring the motion. This is a pure issue of law. The facts are completely irrelevant to this issue. It's a pure issue of law. So you brought it up at the summary judgment. You didn't have to renew it. You could have, but you didn't have to. So fine. In a relevant case, the court has held an order denying summary judgment on sufficiency of evidence grounds is not appealable after trial. So in a prior case, we dealt with sufficiency of evidence. Is there enough evidence? In other words, judgment notwithstanding the verdict, for example. So can you appeal that? Because that's factual in nature. Because a factual record developed at trial supersedes the record established as a summary judgment, it follows a party must raise the motion again, which makes sense, right? So if you're going to get a judgment right off the bat, it's called a summary judgment for a reason. It is a judgment, right? It is a conclusion. If you're going to get a summary judgment on the facts or on the issue as it's presented at the case, right? The amount of facts that are known at that time is obviously different than it's going to be known at trial because we haven't done discovery yet, right? It's a process that comes before discovery. It's based purely on the papers of the person who is filing it, right? These are my allegations of my facts. This is what I believe to be factually true. And a summary judgment is all about, even if those facts are true, you still lose, right? It assumes the facts are true and says, even if those are true, you still lose anyway. You don't have a case, you have no case. Well, what if we say, okay, if the facts are true, you do have a case? Well, as the case progresses and as we do discovery and as things go on, maybe those facts turn out to not be so true, right? Maybe the evidence, as it's actually revealed along the way, shows the plaintiff's claim to be a little bit more hypothetical than real. And we can even do this as far as the end of the trial, if we got that far. Maybe we'll leave it to the jury, because if they come to the right conclusion, I can avoid this problem completely. So I'm just going to hope the jury solves this problem. But ultimately, the jury came to the wrong conclusion. So now I have to fix this mess. So it's like, okay, as it turns out, your facts are BS. You'd had nothing. I don't know how the jury possibly came to this conclusion. Or, as we now know the facts, it's a matter of law. So the jury screwed it up. They weighed the facts wrong. Or the facts as they actually were revealed at trial, as opposed to the hypothetical facts you wished were true. The real facts that were revealed at trial, you never had a case. So basically, you lied to us in the first case. You lied to us in the first instance in that motion. So, we're going to fix that now. And also be thinking about sanctions possibly against the attorney for potentially lying to the court because you fronted that you had things you never had. So we're also thinking about maybe this is sanctionable conduct at this point as well, too. So if it's a motion for summary judgment based on facts, the facts have changed. So obviously you have to renew that because, well, the facts have changed. So the same is not true for a pure issue of law because the facts don't matter and never did matter. The facts are irrelevant. We can decide this on the law. It doesn't matter. So the whole jury thing was a bit So we can decide this. So there was nothing new for the court to do here, because it's a pure issue of law. The conclusions are not superseded by later developments in litigation, and the rulings merge into the final judgment, at which point they are reviewable. So this case was never cognizable in the first place. Okay, the issue is preserved. The reviewing court does not benefit from having a district court re-examine a purely legal ruling because nothing at trial will give a court any reason to question its own prior analysis. Well, I don't know if that's strictly true. That won't give them any basis to re-examine because the court may have thought better of it based on what happened at trial. But, okay, it's true enough. It's true enough, right? It's a pure issue of law. You could have found this way in the first instance. So, there's nothing should have happened that should cause you to re-examine it. That's probably better. Nothing should have happened that should have caused you to re-examine it because it's a pure issue of law. So, but of course in the real world, maybe sometimes, but we'll pretend it never happens. The counter arguments are unpersuasive. The relevant law does not hold that any order denying summary judgment is unreviewable. While an interlocutory order, which is where we appeal while the trial is still happening, denying summary judgment is not typically appealable. So, you can't appeal the denial of summary judgment. That's not one of those appealable things. Please continue at your trial. The relevant law does not insulate interlocutory orders from appellate scrutiny, but rather delays their review. So it's not that you can't appeal, it's that you can't appeal now, right? So, you cannot appeal while the trial is still ongoing about your summary judgment. But you can appeal at the end of the trial, which maybe is a little late, but, well, that's the rule, right? So, wait till the end of trial. Yeah, you should have won off the first of the bat. But you can't appeal until the end. But you can appeal at the end. And while the guy insists that there should be a no two-track system of summary judgment, with factual claims and legal claims follow different rules, that doesn't make sense. Right? There is a two-track rule. If it's facts, the facts change. So, renew your motion. If it's law, it's not necessary. But you really should do it anyway as an attorney. By the way, as an attorney, I would not recommend not doing this. Just file the thing, even if it's a little bit, duplicative, because why not? Why take the chance? But okay. On the contrary, fitting the preservation rule to the rationale underlying summary judgment is consistent with the rule, which of course makes logical sense. Factual development at trial will not change the district court's pretrial answer to pure law. Well, at least it shouldn't hypothetically. Shouldn't do that, but yeah. So a post-trial motion would amount to an empty exercise. That should be true. Finally, while the guy predicts that a separate preservation rule for legal issues will prove unworkable because the line between fact and law can be vexing, the relevant case law demonstrates that they overstate the problem. Courts of appeal have long found it possible to separate factual from legal. Also, by the way, don't even try. Don't even try. Why try? Why try to separate the issues if you're an attorney? Just bring them both. Why even try? There's nothing requiring you to try. Just bring the motion. Right? Is it a fact or is it law? Why even ask the question? Just bring the motion anyway. It'll solve that problem right up. Then you don't have to worry about it. Why even try? That's beyond me. But if you're going to try, courts can figure it out. So if you want to, figure it out, we can figure it out. But why bother? I don't know. Courts of appeal have long found it possible to separate factual from legal. And the Court of Appeals for the Federal Circuit in particular has a bit of a problem with that, by the way, with the mixed questions of fact and law. So I'm not sure that necessarily is true. But then again, the Court of Appeals does for the Federal Circuit deals with patent law, which might be in its own little special universe, but we'll pretend that the Courts of Appeal can do this, which I'm not sure is universally true, but let's pretend. Here, the court does not decide the issue raised on appeal is purely legal and remands to the question in the first instance. So we're not even deciding whether or not this is a pure legal issue. If it is, though, it's preserved. But Fourth Circuit, you can figure out whether it's a pure legal issue or not. That should be fun. vacated and remanded by a unanimous Supreme Court. Thus, that deals with the end of the case of the prison official who ordered a guy beaten up. And the guy won $700,000 a trial. How nice for him. The guy says, you can't bring a lawsuit against me because you didn't exhaust your administrative appeals. The district court disagreed, saying, yes, you did. He exhausted administrative appeals, but that's a pure legal issue. Whether he exhausted, first of all, is it required to do that, which is a matter of state law. So first of all, is he required at all to exhaust his administrative remedies is a question of law that depends on Maryland specific law. So that's question number one. And question number two, assuming he is required, did he actually do that? Which is also a question of law, right? It's not dependent on the thing. And the prison guard says, well, I properly preserved my issue. And the Supreme Court says, maybe you did. Maybe you did because you didn't raise the issue. But if it's a pure issue of law, sure, you preserved it. So go ask the Fourth Circuit about whether or not this is a pure issue of law or not. And figure that out. And then also, assuming it is a pure issue of law, then of course, that only entitles the Fourth Circuit to decide the issue and determine whether the district court was right or not. So even assuming it is a pure issue of law, it doesn't mean the Fourth Circuit was wrong. Or it doesn't mean the district court was wrong. So the whole thing might be a little bit moot, but that's okay. We do it the hard way. And that for the moment brings us to the end of discussion of this case.